Welcome to an extraordinary, historic event here at the Robert H. Jackson Center. A few housekeeping matters. First of all, I'd like to welcome all the media here. I'd like to welcome all the public and certainly welcome our guests. As this is a production here, hopefully you'll treat this as your living room where you're sitting and listening politely to a conversation among our distinguished guests. Initially, I'd like to thank a variety of folks who made this all possible, the folks from Cummins, HSBC, Phillips Lytle, National Fuel, New York Bar Foundation. They've been our principal corporate sponsors throughout. As I indicated, this is a production which will be in your living room. I would ask that you please turn off all the cell phones, cameras, etc. There'll be a reception downstairs, which will have an opportunity to meet our guests, and that's thanks to the good folks at Habitera, Chautauqua Abstract, Jamestown Bar Association, and the Jamestown Area Chamber of Commerce. Also, take this opportunity to invite everyone to tomorrow's opportunity that we have at the Chautauqua Institution Amphitheater, where the Brown sisters will be sharing in a roundtable discussion on the legacy of Brown versus Board. We thank Chautauqua Institution because I believe it's the first time ever they've opened up the amphitheater this early for this interesting event. I'm Greg Peterson, president of the Robert H. Jackson Center. The Robert H. Jackson Center was established in 2001 and is designed to advance the legacy of Justice Robert H. Jackson through education, exhibitry, and by pursuing the relevancy of his ideas for our present generation. One of our guests today, in a 1958 Virginia Law Review article, said, "It is not too early to predict that his already considerable stature as a judge will grow, not because of his very quotable aphorisms and barbs, but because he possessed a sound and independent judgment. He bestowed a deep respect, even reverence, upon the law he administered. He had a seasoned lawyer's approach to facts, and he understood the true meaning of freedom, that it must be gauged by the freedom sought and not by the group seeking it, that it applies equally to all, and that it carries responsibility." We believe those 1958 statements hold true today, and it's part of that legacy that we are trying to preserve at the Robert H. Jackson Center. The event today, I should point out the author is Barrett Prettyman. The event today is the culmination of a series of events sponsored by the Robert H. Jackson Center over 4 months celebrating the 50th anniversary of the historic decision of Brown versus Board of Education. This roundtable of distinguished lawyers who were the law clerks to the justices who decided that case will be moderated by Professor John Q. Barrett. Professor Barrett is a professor of law at St. John's University in New York City and the Robert H. Jackson Center's Elizabeth S. Lene Fellow. He discovered, edited, and introduced Justice Jackson's That Man, an insider's portrait of Franklin D. Roosevelt. That Man, Jackson's previously unknown and never published memoir of FDR and the New Deal, is a Book of the Month Club and a History Book Club main selection. It's received rave reviews. John Barrett is also writing a biography of Justice Jackson that will include the first inside account of his year, 1945 through 1946, away from the Supreme Court and as the chief American prosecutor of the principal surviving Nazi leaders at the International Military Tribunal in Nuremberg. To set the scene, I refer to a recent New York Times article by Bob Herbert. The baseball season was a month old, and the Brooklyn Dodgers and the New York Giants were fighting for first place in the National League. A war hero named Eisenhower was president. In London, Winston Churchill was adding his voice to the cadre of world leaders engaged in the difficult search for a solution to the war in Indochina. And in Washington, on Monday, May 17, 1954, a warm and muggy spring day in the nation's capital, history was being made. quote, "We conclude unanimously," said Chief Justice Earl Warren, reading from the court's decision in the case of Oliver Brown et al. Versus the Board of Education of Topeka, that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. That ruling, the most profound of the 20th century, was the essential first step toward a difficult but phenomenal transformation of the American social landscape. Today we hear about the inner workings of that seminal case, which was before the Supreme Court for almost 2 years. Ladies and gentlemen, in order to commence the roundtable discussion, I'd like to introduce Professor John Barrett.
Good morning. My name is John Barrett. I'm a professor of law at St. John's University in New York City and the Elizabeth S. Lene Fellow here at the Robert H. Jackson Center in Jamestown, New York. The Robert H. Jackson Center is named after and dedicated to the life, work, words, and legacy of Robert H. Jackson, a native of northwestern Pennsylvania, in his private life a lawyer here in this community of Jamestown for 20 years, before he went to Washington and rose through the Roosevelt administration to become the Solicitor General of the United States, the Attorney General of the United States, and then, beginning in 1941, an Associate Justice of the Supreme Court, where he served for the remaining 13 years of his life, except for 1 year away as the chief American prosecutor before the International Military Tribunal at Nuremberg, Germany, following World War II. Justice Jackson was one of the 9 justices serving on the court during the Supreme Court terms 1952 and 1953 as it considered the cases and rendered the decision that we commemorate this spring on the occasion of its 50th anniversary, Brown versus the Board of Education of Topeka, Kansas. The Brown case actually consisted of 5 cases, 4 cases arising from states and 1 case arising from the District of Columbia, which of course is a federal property and not fully a state. The 4 states involved were Kansas, which had the lead billing and thus gives us Brown versus Board of Education from Topeka as the title we use. The other states were Maryland, South Carolina, and Delaware. The court in the Brown case on May 17, 1954, ended segregation of school children by law according to race. It did so in the name of the 14th Amendment, which had been ratified following the Civil War and which guarantees to all persons the equal protection of the law. What the Supreme Court unanimously decided that May 17th, 50 years ago, was that equal protection means that segregation by law has no place in elementary and secondary school education. The court's decision in Brown was the start of legal desegregation in America and the start of the process of racial integration in America, which of course has proven to be an extremely difficult, complex, and unfinished project for our society. But for that start, we here today gather to commemorate and give credit to the Supreme Court. The 9 justices, of course, are no longer with us, but we are privileged to have with us 4 of the law clerks who worked in private, in confidence, for 4 of the principal justices who participated in the court's deciding of the Brown case in May 1954. The law clerks who are with me today are introduced at length in your materials, but I will briefly introduce them and then have them introduce their bosses. The first clerk I'll introduce, sitting directly across from me, is Mr. Earl Pollack. He's a graduate of the University of Minnesota and Northwestern University's Law School. He arrived in Washington in the summer of 1953 to clerk for Chief Justice Fred Vinson, who had been the Chief Justice of the United States since 1946. Chief Justice Vinson, as we will hear, died shortly thereafter, and he was succeeded by Earl Warren, the next Chief Justice of the United States and the author of the court's Brown opinion. Mr. Pollack, following his clerkship, was an attorney in the United States Department of Justice, then relocated to Chicago, where he became a partner in the law firm of Sonnenschein, Nath, and Rosenthal, practicing principally in the field of antitrust law. Mr. Pollack today lives in Sarasota, Florida, and we're pleased to welcome him to the Jackson Center. The next clerk to Mr. Pollack's left is Mr. Frank Sander. Frank Sander was an immigrant to the United States, born in Germany, educated in Boston, public high school in Brookline, Harvard College, and Harvard Law School. Thereafter, he clerked for an appellate judge and then for Justice Frankfurter at the Supreme Court. Following his clerkship with Justice Frankfurter, Mr. Sander also practiced law in the Department of Justice and then in the private sector, and then took the turn into academia. He joined the faculty at Harvard Law School in 1959. He is today the Bussey Professor of Law at Harvard Law School and the director of the Harvard Law School Program on Dispute Resolution. It's a pleasure to welcome Frank Sander to the Jackson Center. The third law clerk, sitting directly across to me, to Earl Pollack's right, is John David Fassett. John Fassett is a graduate of the University of Rochester, and following military service twice in World War II and in Korea, he is a graduate of the Yale Law School. Following his legal education, he became a law clerk to Supreme Court Justice Stanley Reed. And following his work for Justice Reed, returned to Connecticut, where he went into private practice in New Haven, first with the law firm of Wiggin and Dana, and then increasingly in corporate America. He rose to become the chairman and CEO of the United Illuminating Company in New England, in New Haven, a major electrical company, and served in that capacity for an extended period of time. Mr. Fassett, in addition to this work career, is a legal biographer. He is the author of New Deal Justice, The Life of Stanley Reed of Kentucky, the principal biography of Justice Reed, and he today resides in North Carolina. It's a pleasure to welcome Jack Fassett to the Jackson Center. The final law clerk with us this morning on my immediate right is E. Barrett Prettyman, Jr. He is a graduate of Yale College and the University of Virginia School of Law. Following law school, he became the final law clerk of Justice Robert H. Jackson. He was with Jackson for the 1953 term of the court, and he was with Jackson for the start of the 1954 term, which was when Justice Jackson died suddenly of a heart attack. Following Justice Jackson's death, Mr. Prettyman was briefly a transitional law clerk for Justice Frankfurter, and following the confirmation of Justice Jackson's successor, John Marshall Harlan, he was a law clerk to Justice Harlan. So he was at the court for 2 years with a total of 3 justices. Following his clerkships, Mr. Prettyman joined the law firm of Hogan & Hartson in Washington, D.C. He left Hogan & Hartson for a time during the Kennedy administration, served in the Department of Justice, returned to Hogan, and at various later points in a distinguished career has also left again to do public service in the District of Columbia government. He is today senior counsel at Hogan & Hartson. He is a vice president of the Supreme Court Historical Society. He's been here previously for one of our roundtable discussions with Justice Jackson's law clerks from the 1950s, and it's a pleasure to welcome Barrett Prettyman back to the Jackson Center. These gentlemen are both protagonists and representatives in our conversation this morning. They are protagonists because each of them was deeply, fundamentally involved in the court's work that emerged in public on May 17th, 1954 as Brown versus Board of Education. But they are here as representatives, they are here as proxies for the justices who were their employers. As each of them left law school, they got one of the most coveted opportunities for a young lawyer entering the workforce, a clerkship with a Supreme Court justice. And I'd like to begin by asking each of them simply to introduce the boss and describe what that meant and who they were arriving to work for as they arrived at the Supreme Court in the summer of 1953. So Earl Pollack, tell us about Chief Justice Fred Vinson.
I arrived at the Supreme Court in June 1953 to become Vinson's law clerk. Unfortunately, I did not have much of an opportunity to discuss much in the way of law with him because this was the summer period, and in early September, shortly after one night when my wife and I had taken the Chief Justice, given him a lift home to his hotel, He died very prematurely, and as a result, my tenure with Chief Justice Vinson was quite brief.
Give us a little sense of his background. Where was he from in terms of region, and what was his career trajectory that led him to become Chief Justice?
Vinson had come from Kentucky. He had been Secretary of the Treasury, appointed by President Harry Truman, with whom he was very friendly. Subsequently, he was named to the Court of Appeals for the District of Columbia, and then from there he was elevated to the Chief Justiceship of the Supreme Court.
Okay, thank you very much. Jack Fassett, let me turn to you, because in terms of seniority, Stanley Reed was, among the justices represented here, the senior associate justice. As you arrive from Yale to be a law clerk, who was Stanley Reed, and what did it mean to be going to work for him?
Stanley Reed had been born in 1884 in Minerva, Kentucky, a small town outside of Maysville. He had been a country lawyer there and representing tobacco cooperatives until he was touched to come to Washington by the Hoover administration to work as general counsel for the Reconstruction Finance Corporation, which was a Hoover entity. He stayed on when Franklin Roosevelt won his first term, and ended up being made Solicitor General and having the dubious honor of being Solicitor General who argued all of the early New Deal cases, the so-called sick chicken case and the AAA case and all those other ones involving the New Deal statutes that were struck down by the old Supreme Court. Stanley Reed was FDR's second appointment to the court. Hugo Black was the first, and there was a little furor when he was appointed about some of his background, and Stanley Reed, I guess, was deemed to be a safer appointment. He was a country gentleman, a very kind and nice gentleman who had a cosmopolitan education. He'd been brought up in Maysville by a father who was a doctor, and his mother had died at a very early age, but he'd gone to Kentucky Wesleyan University and gotten a degree there, and then applied to Yale University, and Yale recognized Kentucky Wesleyan to his degree there to the tune of giving him credit for a year, and and he ultimately became a graduate of the class of 1906 at Yale, and then he went to law school at Virginia and Columbia, and then off to Paris and studied at the Sorbonne.
It's an upward march.
Yeah, and then came back to Maysville to practice.
Now, Frank Sander, let me turn to you. It certainly can't be the case that each member of the court was from Kentucky. Who was Felix Frankfurter, and what did that mean to be arriving as Felix Frankfurter's law clerk?
Well, about as far from Kentucky as you can think of. He was from Vienna, that is Austria, not Virginia.
Okay.
He was a very complex person, hard to capsule in a short profile. Very interested in the world of ideas, endless interest in the world of people. I think he wrote more letters and received more letters than anybody I know of.
Corresponded with just about everybody, didn't he?
Absolutely. And I think at Harvard Law School, I guess he was very much revered because he graduated at Harvard Law School and then was in the government some, and then came back to teach and was a longtime faculty member at Harvard Law School, and made an arrangement with one of the professors at Harvard Law School that he would appoint his 2 law clerks each year from people who had worked in the lower courts. So the people who got this opportunity were very lucky. They knew something. It wasn't as much of a mystery for us when we went down to Washington, because we knew the prior law clerks. With very few exceptions, they were all Harvard Law School graduates, which was perhaps a mistake, but it was just Frankfurter's simple way of trying to preserve continuity and get people that were known to the recommenders very well. So he didn't have what these days people write endless letters to 9 justices to try and get a clerkship. In those days with Frankfurter was quite different. I think the other thing that was extraordinary about him, he had no children, so his law clerks really were part of his family, and there was a very close relationship between us and the justice. He and I were both very interested in classical music, and it wouldn't be unusual for him at 11 o'clock at night for him to call me up and say, I just heard this concert by X, Y, or Z. What do you think about this person? That was not atypical. So a complex person who had, I sometimes say he was alternatively exasperating and exhilarating to work for.
Now, Barrett Prettyman, you also later had that opportunity, but your longest clerkship and your initial clerkship was with Robert Jackson. As you arrived in that summer of 1953, who was Robert Jackson as a justice of the court?
Well, before I arrived, as a member of the Legal Forum at Virginia Law School, I had him down to speak and spent a delightful weekend with him down there where I really got to know him, even though in a very abbreviated time. And then when I went up for my interview with him in Washington, we had a very wonderful long chat, less about the law than just about theory and life and whatever. And at the end of the interview, he said, you know, we're allowed 2 clerks, but I don't want 2 clerks. I only want 1 clerk. And if you'd be willing to be my only clerk, why, you can have the job. And immediately, of course, I accepted. So that was the end of that. I had not been with an intermediate appellate judge, and therefore was absolutely delighted to be able to go directly from law school into this place on the hill.
Right. So you had no training and twice the responsibility of Frank Sander.
You've got it.
But not twice the pay.
No.
Now,
What was it, $5,400 in those days?
6,000.
Oh, you got more than I did then.
that's where that first clerkship had a,
There were 2 levels.
had a benefit.
I see.
Now, let's talk about these school segregation cases. The 5 cases came to the court before you gentlemen arrived. The court actually took a while to docket them and put them all in motion, but they had been argued to the court in December of 1952, and then in June of 1953, very shortly before you arrived, the court ordered them re-argued following additional briefing on a long list of topics that the court asked the parties to research and write for the court's benefit. So segregation in many forms had been percolating towards the court, and in the graduate school and law school context had been dealt with by the court. And the court was in the midst of grappling with it as you arrive in the elementary and secondary context. Again, let's begin with Earl Pollack. How did you get oriented to what we today call Brown versus Board of Education as a pending matter?
I became involved directly with the case after Chief Justice Warren arrived in September, and I was assigned to assist him on that.
Let's stay earlier. Was there any contact during the Vincent phase?
There was not. There was not that summer, except, of course, among the clerks who were already there was tremendous excitement and interest in the pending segregation cases, and a lot of discussion about it. It was the cases were, of course, recognized as constituting the most important issue before the court at that time.
Was there discussion with your departing predecessors for any of you about this pending case and what was happening in the court that you were now arriving in the middle of?
If there was, I've managed to forget it after 50 years. One of my great regrets is that I never kept a diary or a journal, which would have been very useful to try to answer questions like that today.
Jack, how about you?
I did have discussion with the one former term clerk that was still there when I arrived on June 20th. They had that order for the re-argument with the questions that you talked about came down on June 8th, and then immediately thereafter the court had two special sessions. The Rosenberg case involving the stay of the execution of the Rosenbergs had occurred there, and it was very acrimonious, and had just been over on the 19th, and I arrived the next day, and the one law clerk still left from the prior term there had an assignment from Justice Reed to do a project having to do with a possible dissent in the segregation cases. And so I did talk to him about that. I also saw the justice for about a half an hour before he took off from there. He was going off to medical center where he had his annual exam, and then to Maysville, Kentucky, where he had a couple of farms yet. And he said he'd be seeing me and we'd talk at the end of August. Or he'd see me when he came back through, going off to a place he'd rented up in New York State, in Oyster Bay, New York, for the month of August. But he'd see me then. But we didn't have too much time to talk. And all he said to me, "Are you up to date on the school segregation cases?" He having hired me and not mentioned the subject at all at the time it was hired. And I said, "I've heard of them, but I don't know much about them." And I didn't even know much about him when I had the lightning strike of getting the clerkship. I didn't know much about Justice Reed and was able to find very little. But he said to me as he was leaving, he said, "Well, there's these shelves over there, and they've got all the records and briefs in the cases. In your spare time, get yourself up to date on them." And so that was a total talk with him about it. And then the clerk that was there filled me in on the job he was doing, but he didn't have too much handle on what had happened at the court with respect to him, because they were being pretty secretive with most of the law clerks about what was going on. And so until I started getting these letters from Justice Reed, first from Durham, and then from Maysville, and then from Oyster Bay, sending me these projects. And when he came back through, we had a long conversation about it, but that's getting ahead of the story.
Right. Frank, how about you?
Well, like Earl, I'm not quite sure about this, but whether I had any conversations with one of our predecessors, Alex Bickle. His is an important name in the Brown history, because one of the unusual things about Frankfurter is that he didn't use his clerks for routine work like the certiorari petitions, whether the Supreme Court ought to take a case. He handled those himself, but he would assign major tasks to people that really required full concentration for an extended period. And related to the questions for the rehearing, he had asked his prior clerk, Alex Bickle, to make an investigation of the legislative history of the 14th Amendment to see what light it shed on desegregation. In the end, it turned out not much, but being the professor and scholar, he wanted to leave no stone unturned. So this was in process, and I don't know whether I talked with Alex Bickle about this, but we were certainly very aware of that event.
Okay. From Jack's description of his predecessor writing or doing research for Reed in an expected dissent, it sounds like the climate you're arriving in is one where school segregation is losing. It's going to be struck down?
I had no indication of that. When I finally had my long conversation with Justice Reed when he came through at the end of July on his way from Maysville to Oyster Bay, I finally asked him, well, is the court going to decide these cases now? And he said they're going to decide them. They've got the votes, but the indication was that the decision was going to be to strike down Plessy v. Ferguson, and he and some others were going to be in a minority. But he didn't identify who they were going to be. But we had a big argument about it, and that's the state where I learned that long word, critocracy, because I said, well, aren't they going to be reaching the right decision? I think that sounds like, and he said to me, are you one of those people that believes in critocracy? I said, what does that mean? And he referred me to a book or paper that he had there and showed me that chautauquacy means government by judges. And it was the beginning of a very long dialogue that we had over a period of several months, where we had a very interesting time as he thought over the process of whether he was going to dissent or not. And chautauquacy was foremost in his mind, that he didn't quite think that this was a role that the judges ought to play.
Barrett, as you were arriving and replacing 2 clerks all by your lonesome, did you get any transition briefing or any sense of where segregation stood with the court?
I don't recall any discussions with Bill Rehnquist or Don Cronson about the segregation cases, and I was not aware of their now famous memos that they wrote. But the only discussions I had with the justice gave me the impression that the court was in somewhat of disarray. But it was not clear to me, and I'm not sure it was clear to him, where the votes actually lay, because at their one conference, they had decided not to take a vote. Unbeknownst to me, not that long thereafter, in fact, the day before the second argument in Brown, he began writing a concurring opinion, because he assumed that regardless of how the vote went, the justices either would all be writing, or many of them would, that there would be dissents and concurrences and so forth. And so he was trying to get his thoughts down on paper. I didn't see that draft of a concurring opinion until 4 drafts later, when he finally gave it to me.
Okay. We will catch up to that point in the story. The decision to request additional briefing and the postponement of deciding it at the end of that 52 term, does anyone deserve credit for that? Was that Frankfurter and Bickel? Was that Vinson? Do you have any light to shed on that?
Well, I don't know definitely, but I would suspect, both from the nature of the inquiry and what I've read, that it was largely Frankfurter, but it was not Bickel. It was Frankfurter commissioning Bickel to do this and then persuading the court to, as he said somewhere, have this filibuster. I think that was a phrase that's attributed to Frankfurter. It doesn't sound quite true, but in any event, one of his main concerns was the whole theme of judicial restraint, the issue that Jack referred to. So I think putting the thing off because it was a difficult decision and getting more research seems very much in character for him.
I think there was except for a couple of the justices who were anxious to go ahead and have the vote, most of them felt that it would be desirable to have more time. I think Justice Clark and Justice Reed, and I think Justice Jackson as well, all concurred in that. So what they needed was a device to do it. And Justice Frankfurter provided the device by coming up, he drafted these 5 questions, which they issued as their order. The other thing they did, which is significant in that same June 8th period, was to invite the new administration. President Eisenhower's administration had just begun, and they invited, almost directed, the new administration to file a brief with respect to it and take a position on it. And in this new book that just come out, Black, White, and Brown, issued this week, Herb Brownell, who was the Attorney General, has a very interesting and illuminating piece in it, telling about what happened at the White House when they were advised that they should participate in this. It required the administration to take a position, and Herb Brownell was very important in convincing the president that they should take a position and that they should oppose school segregation.
Right. Now, that's a nice segue. Much of our discussion, obviously, is going to be legal in nature, or the court's work, of course, is legal in nature, but it's connected to fundamental social realities.
And politics.
Where were your justices as men on segregation, as you understood them at the starts of your clerkships?
I understood, not directly from Vincent, that he was opposed to overruling Plessy against Ferguson, not because he was a racist, but rather because of his belief that a decision that had lasted that long should not be overturned by the Supreme Court, that as a matter of stare decisis, that it should be done through action by Congress and possibly a constitutional amendment, that it was a matter of judicial process that motivated him to take that view, which in a way was something that also, of course, dominated the thinking of both Frankfurter and Jackson, although they ultimately, of course, took quite a different view.
Right. Frank?
Well, I just wanted to add this footnote. I think that's exactly right what Earl says, because I remember coming to work on September 8th, and in the elevator, the operator said, "Do you know what just happened?" And I said, "No." He said, "Chief Justice Vinson died." And shortly thereafter, Frankfurter got off his now famous line, "That's the first time he believed in God." So this rather suggests that Vinson was clearly in favor of upholding Plessy and Ferguson, and that Frankfurter thought this was a whole new era that was being ushered in.
Right.
I think he said this before the other side of the coin came in, i.e. the appointment of Earl Warren, which was the other really important thing.
Now, Frank, I think that statement of Frankfurter's was made to Phil Ellman,
Well-
a distinguished clerk of, another distinguished clerk of Frankfurter's, and I think it was not directed solely at the matter of how Vinson was expected to vote, but rather Frankfurter's belief that at long last there was a Chief Justice who was capable of welding the different factions together, something that unfortunately Vinson had not been able to do. It was very much of a fractured court under Vinson, and I think Frankfurter saw the Warren appointment as a chance to overcome that.
I think that's...
A number of people have written, and Earl has just stated, the view that Jackson seemed originally to be in favor of upholding Plessy, not striking down segregation, and then came around and changed his view. I disagree with that. I don't think that's what happened, and I think that his unpublished concurring opinion demonstrates it. I think that at that first conference where everybody was expressing their opinion, and a number of justices, including Douglas, wrote down that Jackson appeared to be in that school. Actually, Jackson, being a very, very, very practical person, recognized that school segregation was going to be struck down, and he was willing to go along with that. But he was very worried about all kinds of things. He was worried about not giving direction to the district courts as to how they were going to do this. He was worried about what legal ground the court was going to base its decision upon. He was worried that the court was going to find fault with the school systems, with district court judges, with the South, and so forth. And having expressed all these concerns, I think that writers today and even justices at the conference got the impression that he was negative. And lo and behold, the concurring opinion that he finally gave to me was negative in many respects, but only in those respects. His bottom line was that he was going to go along with the majority because he felt that the Negroes had made such an astonishing progress in the years since the Civil War, the most astonishing progress in history, that even if once there had been any ground for segregating and dividing them based on race, that had long since disappeared, that they were now equal in every respect, and that therefore it was denial of both due process and equal protection, to segregate them solely on the basis of the color of their skin.
Well,
That's how I read Jackson.
Yeah, I do too. And Justice Reed and Justice Jackson were very close together on their thinking on this.
Well, except that Reed was going to dissent.
He was going to write a dissent, but for the same reason that Justice Jackson was voicing. When Justice Jackson circulated his memo in February, where he used the term, it would be a ruthless use of federal judicial power to overrule this, that was sort of Justice Reed's feeling too. His Chautauquacy thought was the same thing, that Justice Reed had been much in favor of fairness for the Negro race. He'd written the famous Smith versus Allwright decision that did away with the Southern white primaries. He'd written a couple of other decisions, but he just did not think the Supreme Court ought to be doing this at the early stages. And so in that sense, they were, well, Justice Jackson would have done a concurrence on that basis. Justice Reed was he was looking for more time. He's in the conference, he said that Plessy probably is going by its day and is no longer good law, but we need more time for things to occur. He was a great believer in time taking care of things, and he was worried about a whole bunch of subjects that he talked to me about. What's going to happen to the black teachers in the schools if we outlaw segregation? They won't be able to teach anymore, that sort of thing. We collected more materials on subjects like that in the early months while he was still thinking about this.
Now, let's introduce perhaps the legal protagonist, Earl Warren, because on that September 8th, 1953, Fred Vinson goes home to his apartment, and it wasn't called Monday Night Football at the time, but he watches an exhibition game on TV and doesn't live to see the morning. And that vacancy is quickly filled on a recess appointment. Without confirmation by the Senate, Eisenhower appoints Earl Warren and has him in place for the court to begin its term at the start of October. Earl Pollock is one of the law clerks who, I guess, inherits a new chief.
Well, that'd be one way to put it. I think the other two, Vincent Clerks and I, were in something of a state of insecurity because we didn't know what our future was going to be. I think we had temporary appointments by Hugo Black until it was determined whether we were to be retained by Chief Justice Warren. Warren did ask us to continue, and he asked me to stay with him for the second year.
Remind us, because obviously we know him as Chief Justice Warren, but as he's being selected by Eisenhower and as he's arriving, who was Earl Warren on the landscape of this country? And what does it mean for him to be the new chief, put on the court as it's about to start its term, as it's in the middle of these segregation cases?
Warren was a very sharp contrast to Fred Vinson. Both had, of course, extended political backgrounds. But Warren, I guess to use a much hackneyed phrase, was very much of a people person. He would come into a room and he would immediately dominate the scene. He was very impressive physically. He had a big smile. He greeted everyone very warmly, whether he was a messenger or a secretary or anybody else. It's probably a vestige of his days as a very successful politician. He also seemed to exude a kind of integrity, and he was, by his nature of his very persona, he was a very persuasive gentleman. Mm-hmm. People wanted to agree with him. He put people at ease. He had a patience in dealing with people. There was no throwing his weight around. If anything, he ordinarily showed a high degree of humility, which made it much easier for him to become very friendly with and to be liked by the associate justices.
So he was a Republican governor of California, but he wasn't a sort of muscle-bound weightlifting type.
No, he wasn't, but he was not only a Republican governor, but I think in the previous election for governor, he'd received the nomination by both the Republican and the Democratic parties, indicating the extent of his popularity in California on essentially a nonpartisan basis.
You've mentioned, Frank, the Frankfurter quip, which is such a good line that obviously he used it with Phil Ellman, yourself, and a number of others about Vincent's death indicating the existence of a God. Do you, I guess Barrett and Jack, do you remember any particular Jackson or Reed reactions to this Vinson replaced by Warren development and what that would mean in the context of these school cases? Barrett?
Well, I don't remember much from Jackson. Frankfurter was in my office a lot because he was in all of our offices a lot. And I do remember that he was thrilled. There was no question. He didn't tell me that quip, but I could tell that he was thrilled. One element, I think everything that Earl said about Warren is correct, but one element that you left out is that he was a very tough man. Underneath that affability, he really expected things to be done in certain ways. When he sent out orders in the court that something was to be changed or whatever, he expected things to move. And I saw him several times where you could tell he was upset, and you didn't want to be at the forefront of that anger when he went that way.
He sure could stroke you, though.
Yeah,
I
he sure
mean,
could.
after the decision, I told fellows the story last night about having a private session with the Chief Justice, that he called me into his office and put his feet up on the desk, and we just chatted, talked about our high schools together. My justice had already left, and he was such a charming man. He could really be convincing, and I think that was a very important aspect. As to the question of expectations right after Vincent died and before Warren was the rumors running around that courthouse on what was going to happen were rife. I mean, Justice Reed told me about some of the things that they didn't know who was going to be appointed. It wasn't certain for quite some time that Warren was going to be appointed. But when the appointment was made, Justice Reed said he was so happy. He thought that was a good appointment. So I think he had some of the same thought. He got a little unhappy with his fellow Kentuckian, Fred Vinson, because of the dissension in the court and the chief not running the court tightly enough. And Reed always thought highly of Charles Evans Hughes, the first Chief Justice, when he was on board, who really knew how to run the court, and neither Harlan Stone nor Vinson really did.
Frank?
Yeah, just a sentence. It's very hard in these 50-year recollections whether you're really recalling something or you're
Making it up.
well, not making it up, but attributing backwards something that you know happened as your own reflection. I find that hard. But I have a very distinct reaction, maybe because I worked for Justice Frankfurter, that it was as if a cloud had been lifted after Warren was appointed. There was just much more hope and a positive outlook, not necessarily how the case was going to be decided, but that this stalemate had been ameliorated and that good things were going to come from Warren's appointment, partly just because of this very impressive personality of Warren's, and he obviously was pouring himself into this job and regarded this as his primary challenge.
You could argue that almost anybody new would have created something of the same feeling, but it was greatly enhanced by his personality.
We had the two occurrences. Vincent died, and then they had the state funeral at the National Cathedral, where all of us went by direction, and it was quite an occurrence because we sat right behind our justices, and in the next row sat President Eisenhower and Mamie and the Vice President, his wife, and Harry Truman. Bess wasn't there. And then the justices went off as a group. I think all of them went to Kentucky for the funeral there. And when they came back shortly after, the point was made, and the atmosphere was just different.
As we look back 50 years and recall these powerful events, I am certain that I wasn't there. It is a pleasure to be here. We'll take a short break now and resume again in a few minutes. Thank you.
Well, I suppose I should take advantage of this
I think we
opportunity.
should.
So it's for you.
I think we should.
Term and what happened to it could be so important in our late years of our lives. I knew it was an important decision, but I thought,
Well, you know, for one thing, I never really expected that all of this would come out through the papers of the justices.
yes,
I had always sort of assumed, oh, this is sort of locked up forever. Not never be in the public domain. Now it's all in the public.
well, except for those who didn't.
Welcome back to the Robert Jackson Center. We've introduced Chief Justice Earl Warren into the equation, and we are looking forward to the opportunity to learn more about the next form of the process of Brown versus Board of Education. Just a quick reminder, please turn off all cell phones, and photo flashes are not particularly appreciated this time. So with that, I look forward to the second part of this opportunity with the roundtable with the clerks, and turn it back to Professor John Barrett.
Welcome back to the Robert H. Jackson Center. I'm John Barrett, and we're gathered here on the 50th anniversary of Brown versus Board of Education with 4 lawyers who were law clerks during the Supreme Court's work in the 1953-54 term of the Supreme Court, producing the Brown decision. We're with Jack Fassett, who was law clerk to Justice Stanley Reed, Earl Pollack, who was law clerk to Chief Justice Earl Warren, Frank Sander, who was law clerk to Justice Felix Frankfurter, and Barrett Prettyman, who was law clerk to Justice Robert Jackson. Now, the fall of 1953 brought the extensive additional briefing that the court had requested and the preparation, and then in December it brought the second round of oral argument, where these 5 school segregation cases were argued to the court. Were you there for the oral arguments, and what do you recall of that forensic moment in this piece of history? Earl?
I was in the courtroom. The Chief Justice expected any clerk who had been assigned to work on a particular case to be present during the argument. And although I don't recall the dramatic moments of the argument as much as I would like, I do recall very clearly the argument that Thurgood Marshall made. It was very effective. It was very emotional, not by any means confined to arguments about stare decisis or other technical legal issues, but emphasizing the extent to which white and black children who played together, who spent time together, were then suddenly separated along 2 different tracks once they began their public school education. It was a very effective argument. I don't recall Davis's argument.
That's John W.
John
Davis.
W. Davis, who then regarded as really the dean of the American bar, probably a man who had argued more Supreme Court cases at that time than anybody else in the country. It was an eloquent argument, but it was, of course, limited by the fact that his position had to rely to a much greater extent than Marshall's on technical legal arguments as to why the court should defer to the doctrine of stare decisis and not undertake to overrule Plessy versus Ferguson after all those years.
Barrett?
Well, yes, I heard both those arguments too. I don't think I heard all of the arguments that were given because it went over a couple of days, but I do remember those well, and I would add to what Earl just said about John W. Davis, who incidentally had been a presidential candidate at one point. He relied heavily on states' rights in addition to stare decisis, and his theme was, you have even said in your opinion, Supreme Court, that education is a matter for the states. Educating children is not some big federal thing. It's states' rights. It's what the state does. And now, all of a sudden, you're trying to take away from the states this right to decide where children go to school. Why not leave the matter with the states, which I thought was really very clever because that appealed to something which a number of the judges actually did believe in. I must say that in my own mind, I thought the die was cast in these cases when they agreed to hear the cases. It seemed inconceivable to me that as late as 1954, that a majority of this Supreme Court would say that it is still valid under the law to separate children solely on the basis of race when they go to school. So while arguments are always important, and while these were very good arguments, I'm not sure they dramatically affected in any way the result in the cases.
I'd like to agree just briefly with Barrett on that. It frequently is thought that it was the compelling argument of Thurgood Marshall that caused the court to decide the case as it did. I think that is quite an overstatement. I agree with Barrett that the argument did not have that substantial effect on changing anybody's mind.
Not even toward the ultimate unanimity of the court.
I doubt that. I think that many Supreme Court arguments are really more designed to avoid losing than to achieve winning, and
Having lost a few, I would agree.
Yes, and I doubt very much whether it had that substantial effect on the ultimate outcome.
I agree entirely. I don't think the oral arguments, which spanned the 3 days of December 7th, 8th, and 9th of that term, while it was interesting and it was quite a public drama, I don't think it affected the vote one iota. The interesting things that had happened before then were that on November 1st, they filed all these briefs with the answers to the 5 questions from the June 8th order of the at the end of the prior term. And on November 1st, right after that, Justice Frankfurter circulated the long memorandum that Alex Bickle had written on the history of the 14th Amendment. Those things were what the justices had studied, and though they asked some questions of some of the arguers with respect to that, nobody changed their mind as a result of it. Another thing that happened in between here that's very interesting that is seldom mentioned. On December 1st, we remember it because it was quite a big day in the life of we young law clerks. President Eisenhower and Mrs. Eisenhower reinstated the procedure of a White House reception for the judiciary, inviting the justices. And of all things, they sent engraved invitations to each of us, I guess, and my wife, and we had to rent white ties and tails and went off and got to shake the hands of the president and introduced to Mamie and talk with him, and Herb Brownell was there, the Attorney General, and it was quite an occasion. But the timing is very interesting. December 1st, the argument was scheduled to start on December 7th, and there are some stories that go on about the Chief Justice having been taken aside and having had some words said to him during that. It didn't affect the outcome, obviously. But as to the oral arguments themselves, like Barrett, I was very busy working on other cases and doing a draft of another opinion for Justice Reed, so I couldn't go in there and sit there all day, and the justice hadn't asked me to. So I went in and out, but there were certain of them I wanted to hear. I heard part of Thurgood Marshall and part of Spotswood Robinson. We had a special little place where the clerks and the secretaries could go in and see and go in and out. Anybody else, you had to come in through the main way in the court, and it was a real problem to get in for something in demand as that. I particularly wanted to hear John W. Davis, and I did, because as I concluded law school at Yale, one of the firms I interviewed with, they invited me down to New York, and when they heard I'd been recommended to go to Justice Reed, the interviewers ushered me into John W. Davis's office, and I didn't realize what was going on at the time, but he explained to me how he knew Justice Reed, what a fine gentleman he was and whatnot, and hoped I would get it, and so there he turned up. He was way ahead of me on that
You
one.
think he was doing a little lobbying?
It happens, you know.
Now, the court's procedure, and it's an important reminder that the court is not only doing Brown versus Board of Education during this or any term. Its procedure after hearing oral argument is for the justices alone to meet in conference to discuss and vote and then assign opinion writing responsibilities. And so after that oral argument and those oral arguments over those 3 days, the court has a conference and the justices emerge and something is in the process of having been decided or being done with the school segregation cases. Frank, did you have any understanding of the conference and its result?
No, it's one of these questions that I know the answer to now, but didn't then. So I don't want to recreate history.
Okay.
I don't think any of the clerks knew the answer.
Yeah,
to
I
that.
mean, I guess I just want to say we're getting a little false picture of the involvement of the law clerks. The three gentlemen that are sharing the platform with me as law clerks were exceptions. The general rule at the Supreme Court was that law clerks would have no role in this decision because even then the fear of leakage would be so serious. So there were some violations of that by some justices, including my own, but not that there was a report of what happened at the conference, which often justices discussed with their law clerks afterwards, but not in this case.
Well, was it true for the other three of you that there was an information blackout about these cases coming out of that conference? Or did you come to understand where the court was heading?
It was common knowledge that this was very close to the vest, and only the people directly involved should have anything to do with it. I didn't know Barrett was directly involved. We never discussed it at the time. I didn't know who was working on it for the Chief Justice, but Justice Reed had fingered me to be the one working with him, and I'd been working with him since the summer on what he was thinking about doing. But the secrecy was very strict, and most of the law clerks had no idea what was going on. On the December 12th conference, when they came back, I assume we always had the conferences on Saturday afternoons in those days. When they came back, he'd open his docket book and tell us what had occurred, but nothing with respect to the segregation cases. They had no vote. They decided at that occasion that they would not have a vote. They'd continue to talk about it until they got to a stage where there could be a vote. And I think one reason for that is that, as you mentioned, Chief Justice Warren was an interim appointment. He had not yet been confirmed by the Senate, and so he wasn't confirmed by the Senate until March 1st. So their first vote, I'm firmly convinced, he said in his memoirs that it happened in February, but I'm convinced it didn't happen until the first week of March.
I think it was more than that. I think Warren was the the politician
He was working-
recognized that it was a bad thing to get people to commit themselves.
Sure. I agree with
so-
that.
Before they saw anything on paper.
Yeah.
Exactly.
You know, it has to be understood how unusual it was not to take a vote, because it was very customary after an argument that the justices convene and take at least an initial vote. This was not done in that case, I think for the very reason that Frank has pointed out. The Chief Justice, I think, recognized, and I'm sure other justices did too, that it would be inadvisable to take a vote which might freeze certain justices into position before further work and discussion could take place in order to arrive, one hoped, at unanimity. Not only unanimity, but unanimity without dissents or concurrences.
Did you observe your boss, the Chief Justice, doing this informal working on his colleagues toward those objectives?
Yes, yes. I was not present at those sessions.
You mean in one-on-one?
One-on-one.
One-on-one. I wasn't present at those, but I was aware of the fact that he was very patiently attempting to discuss the matter on an individual basis with each other justice, whether conference in chambers or lunch or taking a walk around the Supreme Court building. I knew that this was going on.
Barrett, from your perspective, what was happening, what was Jackson up to, and what was happening in Jackson's thinking in this post-conference period?
He did not tell me anything about votes after that conference. I did get the impression that he thought that a majority clearly was going to strike down segregation. But don't forget, it was early in the next month when he first gave me this draft that he had gone through for many months of what he thought was going to be a concurring opinion. Mm-hmm. And it was right after that when I wrote a memo back, and I've said before that, to show you how naive I was, I wrote that in my office on my typewriter, did not give it to Elsie Douglas, the secretary for typing, as I normally did, gave it to him myself, and it never occurred to me that anybody else in the entire world would ever see that memo, which of course has now been published in books and everything else. But I was quite critical of it. I thought it was very defensive, and I thought it said some things which would give grounds to particularly those in the South for combating any decision striking down segregation. And it was soon after that, I hope not because of that, but it was soon after that that he had a heart attack. And then he was in the hospital when, I'm jumping ahead now a little, but he was in the hospital when the Chief Justice brought his first draft of Brown around.
So Jackson's drafting a concurrence before he's ever seen a proposed approach by Warren.
And before they'd ever taken a final formal vote.
Okay. What was Frankfurter doing during this post-argument phase?
Well, again, I now know that he had some written thoughts too, some kind of a concurring opinion. There were a lot of discussions with Justice Jackson about possibly writing a joint concurrence. We had nothing to do with that in our office. I think the first formal involvement we had was much later, when an opinion had been drawn up by the Chief Justice that was being taken around, and Frankfurter, I think in violation of the agreement, one afternoon came in and showed it to the two of us law clerks and said, do you have any quick reaction to this? And retrieved it very quickly. That was the limit of it.
Okay. What was Reed up to? The previous summer, he had been thinking, researching, assigning your predecessor and you to gather information in anticipation of being a dissenter.
Yes. He, after he arrived back Labor Day, we had these extended discussions about it, and he assigned me a number of additional footnotes to prepare on various subjects, such as what has been the position of the United Nations on its Declaration of Rights with respect to segregation over the years. What has been the position of the Catholic Church was one of them. One of them had to do with the role of the NAACP. Had it ever taken the position until very recently that segregation was...
Jack, didn't you say that one of them had to do with the crime statistics?
He asked me to get... That one came in one of the letters. That was before he came back. He wanted crime statistics compared from various cities, and he identified the cities, one in the north and one in the south, on cities where things were segregated and non-segregated. And I had no idea how to get these things, but Helen Gaylord, his longtime secretary, bailed me out a little bit, and she got in touch with the FBI and sent me up there, and they tried to help me. What I got was not too conclusive, but I had all of these footnotes, and then when the Alex Bickles memo came around and the briefs came around in the 1st of November, he asked me to write 3 more footnotes, one about what the role of the states was, what they thought about segregation in schools when they ratified the 14th Amendment, one what the Congress that proposed it had in mind about it, and he also asked me to do one about segregation in the armed forces, and to show the fact that in an area where the executive branch of the government had control of the situation, nothing was done until an executive order was issued by Harry Truman fairly recently.
Jack, let me stay with you. In early 1954, Reed shows you some drafting he had done of a dissenting position. As far as I'm aware, that's the only justice writing of a proposed dissent in the Brown cases.
Yeah, what happened, you see, was that we went up until the time of the oral arguments, and after that he asked me for no other things. I had many conversations with him about what he was going to do, and I argued with him. I said, you got to look at this from the point of view of the role of our country in the world. And he said to me, boy, have I been hearing a lot about that. He had been having lunch with Burton and Minton, and they've been talking about it. And they were both committed to overruling Plessy. And the Chief Justice, I know, had been meeting with him. But none of these meetings involved any law clerks. The one supposed occurrence of Warren and Reed and a law clerk that appears in Dick Kluger's book, Simple Justice, I'm convinced is erroneous. And the fellow who was identified there as doing it has denied that he said so. So it makes it...
So what about Reed's writing? His
So
draft of a
what
proposed
happened
dissent?
was that we'd done nothing on a dissent after the oral arguments until the court went into recess on February 9th of '54. And out of a blue sky, he called me in there, and he said, Jack, take a look at this and tell me what you think. With sort of a twinkle in his eye. Stanley Reed could be a very pleasant man. We'd been having all of these extended discussions. And so I took it out, and as we law clerks, we each had our own big Royal typewriter and typed all our own stuff in those days. And so I made a triple-spaced copy of what he'd written, and then I went through and made comments on each of the things, and I'm sure each of you did on occasions with things. And I went back in and talked to him about it. And his reaction was sort of a ambivalent sort of thing. I'm sure...
What was the main pitch of the dissent?
The main pitch was that the Equal Protection Clause issue had been settled. History had settled in Plessy and the history of the 14th Amendment. Mm-hmm. So the only question open was whether, under the Due Process Clause, it should be overruled. And he went on at great length, but never came to a conclusion in the thing. And it was yellow pages, and I'm convinced he'd written it the former summer while he'd been off at Oyster Bay and was thinking about it, and that he was just sort of teasing me at that stage. But I took it back, and I kept this whole file of these footnotes and whatnot that I had, and so...
But at the time that you went back to him, is it your view that he had changed his mind by then?
It's my view that he had already told the Chief Justice that he would join an opinion if it was an opinion that he could accept. And I think that's sort of confirmed by Frankfurter's letter to him of May 19th, right after it came down. Frankfurter congratulated him on having joined it, and
I
he's...
thought that was pretty late.
Well, I don't think Reed made that clear to the Chief Justice until almost the end of April, because...
Yes, tell us why, because this
Yeah, I'm interested.
unanimity is part of the accomplishment here. So it's important to try and date it as best we can.
Well, what happened was that in the week of April 26th, Chief Justice Warren took a pen to hand and a yellow tablet and scratched out what he later told me he thought was an outline of a opinion, and it's available now on the internet, I think. He had it typed up into about 3 typed pages, and on April 29, which was a Thursday, he called me into his office. He gave me this document, which was headed memorandum, and he called it an outline. Said that he wanted me to revise and expand it into a full opinion. He said he wanted it to be short, he wanted it to be readable, he wanted it to be non-legalistic, he wanted it to be something that could be understood by the layman, and he said something that even could be published on the front page of a newspaper. And he also said speed was of the essence. Of course, he told me that it was unanimous. I mean, I understood from what he was telling me is that he had just achieved the agreement for unanimity.
In late April.
Yes, in late April. And he also cautioned me about the need for tight security on it, and that there was not even to be any discussion with anybody outside of the Chief Justice's chambers.
Earl, may I ask you a question?
Yeah.
I have seen just recently the draft. Nina Totenberg showed it to me when she had her program. And from a quick look at it, it looked more than the 3-pager. It looked like pretty much the final opinion, yet it was in his handwriting.
No, it's the longhand is something like 9 pages in longhand, but it types up to about 3 pages. And he clearly, in this memorandum, established the framework of the opinion. And also, the memorandum has at least 2 of the most stirring sentences that wound up in the final version, including the hearts and minds, and we cannot turn the clock back. But probably close to half of that 3 pages never wound up in the final opinion.
But my question is, how did he get from the 3-page handwritten draft to the 9-page handwritten draft? Was that, in other words, the 9 pages
No,
was
it
after
went
you were...
from 9 pages longhand with maybe a few sentences on each page to 3 pages typed up. And what he gave me were the 3
And
pages.
at that point, it goes to you as an assignment to
That's right. That's right.
flesh it out.
That's right.
Okay.
You want me to continue on that?
This is where the action is.
All right.
What did you do next?
This was all about.
Well, with the hubris of youth,
Which we had lots of in those days.
I started work on it the very next day and worked about 24 straight hours. And that brought me into the weekend. And this was mostly in longhand at home because I did not have a typewriter at home. Brought my longhand revision into the office Monday morning, had it typed, and I presented it to the Chief Justice with a cover memo, which is also now on the internet someplace, saying that I've tried to carry out your instructions, and I then said that there was, as part of that, this draft included all 5 cases, but I said I strongly recommended that the District of Columbia case be stripped out because you could not rely on the Equal Protection Clause.
That applies only to state governments.
That's right.
Right.
And also, his opinion, or his draft, had made references to both due process and equal protection, and in fact even also referred to constitutional privileges. I felt very strongly that the state case should be tightly limited to the Equal Protection Clause. Among other reasons, if we got into due process, then we have to confront the question of, does the Supreme Court really want to rely on substantive due process, which involves all kind of issues for the courts? I thought it should be limited to Equal Protection Clause, and my revision so provided. But he agreed that that's the way it should be restructured, and that there should be a short opinion on the D.C. case, which was assigned to the other 2 clerks in my office. And he accepted the entire revision that I gave him. What happened the next few days, there were a couple of stylistic changes in the May 3 revision. There was some stylistic changes on the 5th, I think, and on the 7th. Didn't amount to much. Also, footnotes were added that week. And then on Friday, on Friday of that week, that was May 7th, the chief decided that this opinion was now ready to be circulated to the other justices.
Right.
And he prepared a cover memo, which in large measure repeated what he had told me on April 29 about his concept of the opinion. The cover memo said that here are these drafts for discussion. And he said, as you'll see, the opinion of the drafts are short, non-legalistic, and he says that they should also, above all, be non-accusatory, as he was already thinking in terms of acceptability by the South. That Saturday, he took copies and delivered one to each of the justices who was present in the court at the court at that time. There were 2 justices who were not present, Minton and Black, and another clerk and I.
Well, and Jackson, who was in the hospital.
That's right, and he delivered it personally to Jackson. Quite right, quite right. We delivered Minton's copy to him at his apartment, which was, I think, located just across the street from the Supreme Court, as I recall. And then we went out to Alexandria and delivered Black's copy to him while he was in his tennis clothes on the tennis court. And he stopped the game and thanked us.
Reading.
Yeah, I don't think he read it right then and there.
Now,
But that was May 8th.
Tennis
Right.
first.
Saturday,
Tennis
May
first.
8th. Now, for all the security strictures, it's probably shortly thereafter that Frankfurter quickly shares a peak with you and your co-clerk, Jim Vorenberg.
I think so. I can't place the date, but that would fit in with this picture, yeah.
Right. What was Frankfurter's reaction to the long-awaited draft by Chief Justice Warren?
Well, my best recollection is that he was very pleased because he thought it should be unanimous. I think he'd come around to that. He had some serious concerns about the role of the judiciary that we've talked about and judicial restraint that he's a great proponent of. And so I think he had these concerns, but he saw this movement towards unanimity and clearly felt that was the most important thing. So he was ready to jump on the bandwagon.
Now, Barrett, as we've said, Jackson was in the hospital, and Earl has mentioned that Chief Justice Warren personally delivered the draft to Jackson. Pick it up there and tell us what happened.
Well, Frank, this is one of those things I actually remember.
At least you say so.
Yeah. I do remember quite well. I happened to be with Jackson in his hospital room when Earl Warren came by, and he made it clear very quickly what he was there for. I excused myself and went down the hall. I waited until a nurse came down and said that the Chief Justice had left. I went back. Jackson by then had read the opinion, didn't say anything about it, handed me a copy and said, go read it. I went down the hall again, I read it, came back, and we talked about it, and it was very obvious that I guess the best word I can use is that he was relieved. He was very relieved that something had been presented that he could go along with, even though, I have to emphasize, there were parts in it that he differed with Warren on. For example, Warren said that the history of the 14th Amendment was inconclusive about what the framers felt about segregation, segregated schools.
And that, of course, was based on the
Bickle
Right,
memo.
right. Jackson thought it was quite clear what they thought, that they had in effect approved segregated schools in the district, for example, but he didn't care what the framers thought about this now current problem. Couldn't have bothered him less, and he thought that you had to interpret, as a very practical man, which he was, he thought you had to interpret the Constitution in terms of today's world, and therefore he put that problem to one side. So he had different approaches from what Warren had, but basically he very much liked the idea that it was simple, short, people could understand it, you could easily agree. You tended to read those words and say, yes, yes, when you separate people on the basis of race, you are denigrating the black race. And
Here's a speculative question for you. I've sort of always wondered whether Jackson's heart attack, along with Warren's appointment, was one of the things that made possible a unanimous opinion. Do you think that his physical condition had something to do with his lowering his acceptability point and going along with the opinion, or do you think this would have been the same if he hadn't been ill?
It's a fair question, but I didn't see any signs that he was not robust in mind. I think he was genuinely pleased. Now, he did make some suggestions about changes, one or two of which Warren, one in the Bowling opinion, for example, that Warren accepted, but several of his suggested changes Warren did not want to accept because they related to segregation generally. And as you know, Earl, Warren was absolutely adamant about restricting this opinion to education. And he did not want to intimate that any segregation was going to fall in any other area, even though he knew perfectly well that it would. That was the politician in him, and very wise, I might say. But no, I think Jackson, he was so pleased that there was no blame, and he liked it. He thought it was a masterwork, whether it was yours or Warren's. So I don't think his heart attack played a part in that.
Jack,
As I said before, when he told the Chief Justice that he's going along, or when there was a clear understanding, it was, of course, all based upon the opinion being something that he could accept. But Justice Reed had done nothing further on a dissent. after December. And they had a conference, even though they didn't have the vote until, as I've said, probably first week in March, right after Warren was confirmed. But they had a conference on January 16th having to do, looking forward to the problem of a decree, how it would be implemented. The Chief Justice, I think, my understanding is, had hopes to handle that all in the original opinion, and of course learned quickly that was not going to get a consensus on that subject, and that's when they decided that they were going to have the further argument the following term. But Reed did nothing on a dissent after that. I'm sure he had, if he had not expressly said so, he had impliedly said so to the other justices that he would go along if it was an opinion that was acceptable. He still had the idea that due process was better than equal protection as the way of doing it, because like Jackson, he thought the history on the equal protection clause on the 14th Amendment was fairly clear. He didn't agree with Alex Pickle's conclusion that it was inconclusive too.
Now, it moves very quickly. Obviously, Warren's starting to write in late April. We're now around May 10th, and it's only 7 more days until the opinion is announced. There's tinkering, suggested language, some is accepted.
Comments came in from the other justices, and there were very, very few, and they were essentially word changes or stylistic. For example, Jackson, and this relates exactly to what Barrett was saying before about the way that Jackson was looking at the issue. Jackson added, with the chief's agreement, a sentence saying that blacks had progressed tremendously since the time of Plessy and Ferguson, and so that sentence was added. Frankfurter made a change which I regretted. The chief had, and this was one of the sentences that was in the original memorandum about the effect of segregation on hearts and minds, and the sentence in the May 3rd draft said that this would have, segregation would be perceived as putting a mark of inferiority on the blacks. And that seemed to me very appropriate because it directly refuted the Plessy premise that if blacks saw a badge of inferiority in segregation, it was a matter of their own perception and not reality. Frankfurter, I'm sure he had good reasons for it, asked the chief, and the chief agreed to change mark of inferiority to something like generates a feeling of inferiority, and that's the way that came out. Burton, I think, wanted a change from a phrase from some southern states to some states, eliminating that. He even asked for that we identify the case names of the 4 cases more specifically in one of the footnotes. Clark did not have any particular change that he wanted to make, but he expressed concern about the fact that one of the citations in the opinion was to an article by Clark. And,
Not him.
Yeah, not him.
and he was concerned that the reader might get the idea that Tom Clark was the author of that article, and so to accommodate him, and in complete violation of the strictures of the Harvard Blue Book, which we always sought to follow, we put in the initials KB in front of Clark so as to avoid any confusion as to whether Tom Clark was the author.
Do you remember this change in bowling, the DC case, Earl? Jackson had suggested the addition of a sentence, "The equal protection of the laws is a more explicit safeguard of prohibited unfairness than due process of law, and therefore we do not imply that the two are interchangeable phrases." And then Black came along and convinced Warren to put in the word "always." So therefore it read, "We do not imply that the two are always interchangeable phrases."
No,
And Jackson was very upset at that.
Dick Flynn, one of my fellow clerks, was, after I had suggested the removal of the DC case from the state cases, was assigned the bowling and Sharp. So I really was not involved in the revision of that one.
The only reason I know this, I wrote a contemporaneous memo about that situation, and that's what it said.
My impression is that Justice Reed accepted the two opinions when they brought down on that day without the...
I don't know of any comments that he made, and I know that Douglas sent in a letter saying that he wouldn't change one word.
Hugo
And
Black
I don't
from
recall,
Alabama.
I don't recall any changes requested by Black.
He had signed on long ago.
Right. Right.
He wanted to decide it the whole way in the prior term. Hugo Black was one of the most ardent supporters of overruling Plessy.
So there were very few changes, and then, so,
Well, let's go to May 17th. The next.
well, before you get to May
Okay.
17, you have to get to May 15, which was a conference.
Right, Saturday.
And it was at that conference that all the justices formally signed off, figuratively, on the drafts which had been circulated and revised that week. And it was then decided, we're going to announce this 2 days from now, on Monday. And that is exactly what happened. Again, without any advance announcement of what the intention was, with the result that many of the law clerks for other offices were not even present when the case was delivered because
My
of tight
recollection is
security.
My recollection is that most law clerks were there because their bosses said, "Well, I think you ought to be in court today," or something like Frankfurter said to us.
Well, Justice Reed came through and said to me, "Jack, this is the day you better be in court." And he'd also told Helen, his secretary, but unfortunately
your
my
co-clerk,
my
yeah.
co-clerk had gone off to lunch somewhere,
Yeah.
so he missed it.
Yeah, there were a number of clerks who were off to lunch and who were very angry later
Oh,
on
yes.
that they had missed the event.
Now, Barrett, for the first time since the end of March, your boss was back that morning.
Yeah, Elsie Douglas, his secretary, told me that he was coming in for the opinion, so I knew it was coming down. But that was, not that long ahead of time, and he did, in fact, arrive, came up through the usual way, the basement and the back elevator, and word began to get around the court. So that's several clerks. That's the first
Ellis
indication.
McKay, who was Clark's clerk, whose office was right next door to Reed, had gone down to the print shop, which is in the lower confines of the Supreme Court building. All their printing is done in this very confidential place down there that morning, or just before noon, and to get an opinion of Justice Clark's that was going to be released that day, or that he was working on. And he saw these huge piles of packages of opinions. They get them ready to give to the press and whatnot as soon as they're handed down, and they had no indication of docket number on them, like always it appears on that. And Ellis came back up and told his co-clerk, who then contacted me, said something's going to happen. So there were rumors traveled fast in there, even though the security was very good. There weren't many people that were forewarned.
And I think the security was remarkable in that I don't think there was any public leak.
No, I don't think so.
It was kept under wraps as far as the court itself is concerned.
How did the lawyers come to be present? Would they just
They
be
ca-
present every Monday?
Every opinion day at that stage.
Well, now, wait a minute. I wanted to ask you about this because I did not see Thurgood Marshall. I was sitting
No,
in
he
a way.
was in New York. I think the reports are that he was in New York.
No, but other reports say he was in the courtroom.
He was in the courtroom, and he made much in his oral histories
And he
of
put a picture
watching Justice
A
Reed.
picture was taken of him right outside
I
the
see.
courthouse.
Yeah.
So I don't, I wondered if you knew who called him. I mean, sounds like something Frankfurter might.
Well, yeah, but Barrett, those were the days, long since gone, when the court would deliver its opinions only on Mondays.
Right.
And so lawyers could show up on Monday thinking, well, maybe this will be the day. Today, the opinions can be handed down almost any day.
Well, in the Separate but Equal George Stevens film on this case, there's a scene where Justice Marshall is in New York, picks up the phone, and he says, "Oh, okay, I'll catch the midnight train or something," and so he got the call. I don't know whether that was just made up.
That's a fiction.
Yeah,
Does anyone recall John W. Davis being present?
I don't think he was. No, I don't think he was either.
Okay. Now, the announcement itself can be a fairly mundane event, the announcement of a Supreme Court opinion, you know, the author reading an opinion. I take it this was not a mundane event?
Well, it was in one sense.
Mundane until about 2 or 3 rather unimportant opinions had been read. Then it became non-mundane.
You got to recognize that May 17th was getting very close to the end of the term. At that stage, the terms really usually adjourned June 1st. So you only had about 2 more opinion days. So the tenseness was arising because everybody thought something was going to happen. But there'd been, as far as I know, no leak even amongst the law clerks prior to just before noontime when word got out that Justice Jackson had come for that occasion. And
as
then
a matter of fact, the first AP that went out, even after he had begun reading, indicated that the result couldn't be determined from what he was reading. It was only when he came to a key phrase where he inserted a word that was not in the opinion, the word unanimously. He has said in an interview that he heard a reaction from the crowd at that word, and I remember a great intake of breath. I mean, the people present went like that because that's the one thing that they had not expected.
that
for
was
sure.
dramatic, yes.
Yeah.
And that's what Thurgood Marshall made much about. He came there and said he sat there and watched Justice Reed because he'd heard this rumor that Justice Reed was writing a dissent. And so he wanted to look him in the eye as it came down, and as it came down, he nodded to Justice Reed, and Reed nodded back and gave him a big smile, and he realized that he had joined it. That's one of the, I think that's a very true statement of what happened, contrary to some of the histories that have come out, quite a few of them that have Justice Reed crying as it came down, and other ones that have him receiving an ultimatum from your boss, from the Chief Justice, just before it came down that, Stanley, you've got to join this now, citing a law clerk being with Reed when he had this conference, when we know that the Chief Justice would not have had somebody's law clerk, even somebody working on it at that stage. So there have been some myths, and some of them, once they get issued, they get propagated.
The decision, of course, unanimously held that separate but equal has no place in education, and then deferred the question of how segregation was to be remedied. Were there misgivings among your bosses or among you as clerks about this approach to the remedy question?
Well, I think in our chamber, we then had some discussion about this whole question about deferring the enforcement, and Frankfurter, I think, was one of the leaders for that move to put the defer the enforcement question, and then came up with this phrase, "with all deliberate speed," that finally appeared in the Brown 2. So
1 year later.
1 year later, yeah.
Right. Was that necessary to accomplish unanimity?
Absolutely, absolutely. In fact, the idea that the court could have said, we now order admission of the plaintiffs and the destruction of racial segregation forthwith, I think is essentially, well, to put it mildly, unrealistic.
But it's
Not-
what the plaintiffs asked for.
That's what the plaintiffs asked for, but plaintiffs frequently will, I say in damage cases, may ask for billions but not expect that they're going to get it. But no, there are two reasons why that really would not have worked. First of all, it would have absolutely inflamed the South, would have lengthened the time of resistance, made it much longer than the long time that it took. And second, there would never have been unanimity. There would never have been unanimity. And I think at most there probably would have been what I think would have been a disaster, maybe a 5-4 or 6-3 decision, maybe spanning 100 or 150 pages of concurrences and dissents. There would have been no authoritative voice of the Supreme Court on this issue. And it's very easy for some authors today to look back and say, well, you know, it would have been better if we'd just done it that way. But I just don't think it's realistic. Black subsequently told his law clerk that he thinks the court should have ordered desegregation forthwith. And Warren has expressed at least some sympathy with that, but I think that is speculation after the fact. And the only realistic way of achieving unanimity and avoiding dissents and concurrences was to follow the two-step procedure that the court followed.
Let's conclude by taking the 50-year perspective that we have on this as an accomplishment of the Supreme Court, but as a social issue that continues to bedevil the country and definitely remains on the list of unfinished projects. What is the accomplishment and the significance of Brown versus Board of Education from your perspective as an insider and as a proxy for one of the creators of as much as the court got done in the 1954 decision? Frank?
I think this is one that's really difficult to cast yourself back 50 years, because I think many people thought at the time the problem is solved. Marshall is said to have said that in 5 years from now there won't be any more segregation. Well, that obviously has not happened. I think, I'm intrigued by the fact that some Afro-American authors recently have criticized the court and said maybe it would have been better if Plessy and Ferguson had been forcefully affirmed, that is, expecting real equality but still separation. I don't agree with that, but I think it's a symptom of the fact that in terms of integration, we haven't gotten very far. I think the real meaning of the case is in terms of a statement of national ideals and policy and interpretation of the Constitution. It's interesting in Massachusetts, as many of you know, we've had this whole issue of gay marriage, and the Supreme Court of Massachusetts there used the Brown notion and quoted the sense of separate is never equal. So I think...
And coincidentally, its process of approving same-sex marriage takes legal effect next month on May 17th.
That's true. I think that's a coincidence, but
That's remarkable.
so I think one has to separate what the case means in the broader sense, which I think is terribly important, and one couldn't imagine another result, to its narrow effectuation, which I think has been disappointing, and I'm sort of surprised that these sophisticated scholars have made this argument that perhaps separate but equal, they would have achieved more.
There's been an awful lot of criticism of what has happened in the 50 years that we haven't gone as far as we could. And I'm sympathetic with that, but I think when you get old, you start looking at the big picture a little more. And the big picture of Brown was not just public school desegregation. It was the cornerstone for dealing with racial equality in all areas. And as a former corporate executive, for example, what it meant in the employment patterns of companies. I had the first 2 black directors on my board of directors after I became a head of an electric company. And in politics, you see black people at the top level and in the legislatures. You see it in every area of our society. That all goes back to Brown versus Board of Education. Now, the public schools have problems. There's no question about it. But most of them don't have any basis in the Brown decision. And like Frank, I think it would be a terrible decision if they'd reaffirmed Plessy. But you know, we've got problems with housing and with economics and with parental control and whatnot. But that does not negative the very many positive things that have come out of it.
That was exactly the point that I was going to make, differing with you just a little bit, Frank, and that is, I think you have to segregate, if you will, education and the rest of the world. In education, the progress has been disappointing. It has been dramatic in some areas. In the District of Columbia, they did away with segregated schools at that time right away, and in many other parts of the country. But overall, we are seeing more and more segregated schools for whatever reason. But Brown was the beginning of dramatic changes. At the time Brown came down, you had separate drinking fountains for blacks and whites in the district. African Americans could not go into Constitution Hall. You had these tremendous burdens that began to be lifted with that decision, so that black politicians began taking over in cities and legislatures, all kinds of dramatic things that have happened. And we mustn't overlook that. That all really originated with Brown.
Earl?
We sometimes hear comments that the promise of Brown against Board has not been realized. You really have to ask the question, well, what is that promise? Brown against Board did not promise the end of racism, although I think Brown has had a profound effect in reducing racism, as the separate walls have, to a great extent, at least when compelled by state law, have been broken down. Brown did not promise the end of discrimination, which is still undoubtedly a national plague that has to be addressed whenever we can. And Brown did not promise integration. What Brown was all about was a matter of attacking compelled segregation under law. It was not aimed at creating racial balances in our institutions. It was not intended or designed as an end to the horrendous black poverty that continues. It had a very important target, which I think it very successfully addressed, and that is ending the blight of post-slavery segregation compelled by state law. So from my perspective, I think the promise of Brown has been now realized, and that it, I think, deserves its prominence, which we are celebrating here today, as very possibly the most important decision in the history of the Supreme Court.
Amen.
Ladies and gentlemen, please. please join me in two activities, one of which you've already anticipated. But before I ask you to applaud again, I took the occasion for whatever number time in my career as a lawyer and a professor to read Brown versus Board of Education last night in preparation for today's conversation. I think one of the most profound things any citizen can do is read an opinion that Chief Justice Warren deliberately wrote for all of us to read. And in those words, which are not about utopia, but are about the abolition of a kind of legal line drawing that once may have had a place but today has no place, one finds the genius in the accomplishment of that decision. The second thing I'd ask you to do is join me again in thanking our guests, Jack Fassett, Earl Pollack, Frank Sander, and Barrett Prettyman, for a wonderful conversation. I'm John Barrett from the Robert H. Jackson Center in Jamestown, New York. Thank you very much.
Who would have expected this kind of applause? Ladies and gentlemen, if you want to join us, reception downstairs, the Robert H. Jackson Centers. We'll be hosting a reception to say hello to the various clerks. Please join us. Thank you very much for your patience, and thanks for all the participants. Craig, why don't you explain to the crowd what... I'm out of business. I guess so. Hey, ladies and gentlemen, just so you... Reception downstairs, but just what we're going to do here in a few minutes, we're off camera, C-SPAN-wise, but we're also, the essay contest winners throughout New York State are going to spend a few minutes here asking questions of this panel, some questions that 11th graders might be interested in. So to the extent you want to watch and observe, feel free to do so. Otherwise, certainly go down to the reception. You have choices, but that's something that's going to happen here in a few minutes.
used to. I wish we still did.
Max, you've got the microphone. Why don't you start us off here?
My first question is, what was really the hardest social, I'm sorry, let me rephrase this. What was the hardest, the main controversy that you felt within yourselves in really deciding whether or not that separate could ever be equal? What was the hardest ideas you guys had to struggle in making a decision whether to integrate the schools, basically?
First of all, I think we should make clear, despite some of the emanations that have occurred here, Justice Jackson used to have a wonderful phrase to the law clerks. He said, remember, you're not confirmed by Congress. So we didn't make this decision, despite some of the involvements of some of the law clerks. I think it was our justices who made these decisions.
But if you're asking us what difficulty we personally had in reaching whatever decision we did,
That's what I meant.
I don't have any problem answering that at all. I just never had any difficulty at all. I mean, I thought the time had long since come. It was overdue. And the only thing that really bothered me was if we were going to have a fractured court where we had all these 9 opinions and all over the lot and everything. That bothered me. But in terms of the essence, the real issue, I didn't have any difficulty. I had a lot of difficulty with figuring out how it was going to work, because one of the things I did on a special committee, which we didn't get into, was